Do this in order to have a good prenuptial agreement. First, open communication with your partner. Assume, in my case, you have been married, you have a child. I want to protect my home, my assets. I would like my child to get everything in case I die, because let's face it, when we are marrying someone, we don't know the future. Discuss about, do we want spousal support for each other, or whoever is earning more? Are they feeling okay if the other spouse will take care of the children, to then not only pay child support, but also spousal support? Under California law, the money before marriage is always separate property. However, sometimes it's commingled. So let's say you have a bank account that is your separate, and you start earning salary during the marriage and put that salary into the bank account you had before marriage, commingled. And 20 years later, you cannot claim that to be your separate property. However, prenuptial agreement can separate that. That discussion alone will bring you and the partner to think about, how do we plan our financial future? Do we want to have children? Because it will affect the prenuptial negotiations. For example, if one spouse thinks, I want to have 3 children and stay home, and the other spouse says, I don't want to provide for everything, then this is a conversation for prenuptial agreement, how to protect one spouse or compromising in this type of situation. Prenuptial agreement in itself is a test for maturity of both people. Negotiating it, talking about it, makes them already understand how they handle difficult conversations. And couples who can have difficult conversations, most likely going to stay married. So if for whatever reason one person thinks prenuptial agreement is not romantic, this is a fantasy world, because 50% of marriages fail. And if you don't think about it, then you're going to casino and playing a red and black game. So communication and discussion is very important for starting a good prenuptial agreement. This is what it means to fully disclose in a prenuptial agreement. A prenuptial agreement will include assets and debt and income of each spouse. So what it means is, even assets outside of United States, anywhere else in the world, need to be included. Even if the spouse thinks, it's my inheritance, it's the gift, I don't want the other spouse to know, you still have to disclose. Because one of the reasons prenuptial agreements get set aside, there is no full disclosure. For example, if you plan to get inheritance, according to California law, inheritance and gift, even during the marriage, is considered your 100% separate property, meaning it's not divided 50-50. However, in the discussion, when you have the prenuptial agreement, you can also say that, for example, if you accidentally transfer your inheritance money into a joint account, but you don't want this to be commingled, you have, for example, 30 days to reverse the transfer in order to avoid commingling. That can be defined in a prenuptial agreement. Or you could say, whatever we have in our joint account, we both contribute, and then you can discuss how much for our joint expenses, and whatever we choose to be our joint money, that is considered community property. You can also add in the prenuptial agreement that if we purchase a home and I pay for my separate property, I can get reimbursed dollar for dollar, or at 10%, or proportionately to the increase of the value of the home, because California law 2640 Family Code section says you can only get reimbursed dollar for dollar. So you have negotiation power. And then you can also say, if I put my spouse on the title, then the spouse and I are jointly owning this property as community property, with right of reimbursement or without right of reimbursement. And then if we put, for example, some type of improvement in the home, do you want that to also get reimbursed or not? All of that can be discussed. Student loan, how do we treat that? During the marriage, if we decide that one spouse is going to get student loan, we pay it out of the community, and the spouse doesn't need to reimburse it if the spouse finds a job within a certain amount of time and starts earning money. All of that can be created. One thing cannot be created is the punishment clause. California is a no-fault state. What it means is I cannot put enforceable clause saying, if you cheat, you gotta pay me $50,000, because it's against public policy. What we also cannot put is child support provisions. Let's say we have children and I say, I don't want to pay more than whatever in child support. Against public policy, because children don't sign this agreement. It's not in the best interest of the children to have a certain amount. If, for example, this amount is lower than the standard semester amount, meaning the calculated guideline support. If it's higher, that's a question. That could be potentially not against public interest because it's benefiting the children. We can also make agreements about private school. All type of agreements are acceptable if they're not immoral or against public policy. Avoid making this fatal mistake. Don't wait until the last second to get the prenuptial agreement signed. 7-day rule is designed for a purpose, to give the cooling off period. It technically is not called cooling off period. I call it cooling off period because there is a 7-day of the time frame where prenuptial agreement cannot be touched, meaning the final version of the prenuptial agreement until it's signed, which is before the wedding, cannot be touched. Otherwise, it's going to be invalid as a matter of law, because usually what happens, one spouse proposes the prenuptial agreement, the other spouse goes and finds a lawyer. By the time the lawyer looks at the agreement, the wedding is... So, no, this is not acceptable. Best rule of thumb, propose a prenuptial agreement 3 months before the wedding, so that the spouse can find a lawyer, potentially negotiate. Otherwise, the prenup could be set aside because your spouse didn't have a chance to voluntarily negotiate because of the time crunch. Sometimes what happens, people give the other spouse the prenup right before the wedding when they're standing in the wedding dress pregnant in church and everyone is waiting. That would be coercion, duress, violation of 7-day rule. This prenup would be not valid. Avoid that at all cost. The prenup is not the finish line. It's a negotiation process. Yes, you can sign this agreement and then later things develop, you can always change it. However, I do suggest to have a really, really good negotiated prenuptial agreement without pressure, with full disclosure, with negotiation. And life happens. If that is not possible and you get married with a prenup you don't like, and then 2 years later you decide to change it, it's called postnup. Postnup is like miniature divorce. Why? Because you have to determine what was separate property, which you have in the prenuptial agreement, how much community was accumulated, and what is being transmuted, meaning what portion of community or separate is being transmuted to community or separate. It becomes, postnuptial agreement has way more level of fiduciary duty, because once you get married, it's like a business partnership. You owe each other fiduciary duty of disclosure. So postnup, for example, you have to disclose not only assets and debt sheet and income, you have to attach proof and estimation of all assets. So if you have businesses, that needs to be evaluated. If you have homes, it needs to be appraised. If you have whatever you have, it needs to be with bank statements, with appraisals, with deeds attached. So the process is much more costly, much more expensive. You would have 2 lawyers for the prenuptial agreement and postnuptial agreement. You always want to have one drafting attorney and one reviewing attorney. And you can also amend a prenuptial agreement. Amendment is potentially 1 or 2 pages, modification to 1 or 2 provisions. So you don't need to have a full postnuptial agreement. That is also a possibility. This is why it's important to hire someone like me. One attorney from a different firm is reviewing attorney, one is drafting attorney. It cannot be partners in the same firm because of the conflict of interest. It also cannot be the same lawyer drafting and reviewing because of conflict of interest. Unlike in estate planning attorney can draft for both spouses. That is impossible in prenuptial agreements without making it invalid, right? So if a lawyer drafts and reviews an agreement, it's invalid. So we stay away from that. And also same applies for postnuptial agreements, marital settlement agreements, for any type of agreements where the interests from both spouses are different from each other. They have different goals in mind. So now, if you think about how to choose a lawyer, it has to be a family lawyer. It has to be California practicing attorney, not from another country, not from another state, California. Very important, because when the prenuptial agreements, if they were to be set aside, you don't want your spouse to come and say, well, my lawyer didn't give me the right advice. I didn't know what I was signing. When a California family lawyer, ideally someone like me, family law specialist from the state bar specialization, who will explain line by line what the prenuptial agreement means and also send memorandum of understanding, that makes it harder for the other spouse to set it aside. Another thing to consider, if your spouse just arrived to America, or even if they lived in America but they don't speak the legal English language, hire an attorney who speaks their language. I also suggest, if higher earner, higher net worth person is marrying someone who is less financially privileged, pay for their lawyer, because what you don't want to hear when in a divorce, potential divorce, they want to set it aside because I didn't have the money to negotiate and pay my lawyer. You don't want to hear that. Whatever it costs to pay for your lawyer, for their lawyer, to protect your assets, will pay out in court 10x, because as you know, divorce in California is very, very expensive. It can easily cost $50, $100, and more thousands of dollars if the spouse tries to set it aside. I hope you liked this video. Please like, subscribe, share my channel with your friends who might need this type of information. And if you have any recommendations for videos for the future topics, please comment down below, and I will see you in my next consultation. Bye!